All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in our cause number CV140037, Krenzen versus Katz. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the party that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you may desire. We have read the briefs. We've conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Samuels, you may proceed. And the bailiff tells us that our time clock's malfunctioning, so you'll start out with 12 minutes and then he'll add 8. So.
Thank you.
We really want you to have those extra 8, so.
We're quite seen it like that. But
May it please the court, I'm Mike Samuels. I represent the appellant, Lori Krenzen. She's over here to my left. As you know, this is an appeal from a dissolution action, and the thing which happened, which is the most important, was that the court set this matter for a 3-hour trial. That's what started the whole process moving. It's our position that wasn't enough, and as a matter of fact, enough time. And as a matter of fact, that was the position of the attorney for the wife at the very moment that this occurred. The attorney filed a motion for an extension of time. Ultimately, this was back in 2013.
let me cut to the chase, because I
Sure.
think we understand all of
I
that.
believe you do.
And Judge Norris said many times, no relation to this Judge Norris, that your client needed to retain some sort of forensic analysis and couldn't just dump a bunch of records on the court. It doesn't appear that was done, but equally importantly, where is there a distinct offer of proof about what the additional witnesses would have said about business and finances, not just a generic disclosure?
Well, Your Honor, that's a good question, and I believe that comes from the Gamboa versus Metzler case is really the one that I looked at with respect to that issue, and what it comes down to is, do you need to make an offer of proof? And the Gamboa case involved a personal injury action. There was an award of damages. There was an agreed upon schedule in that case. According to Gamboa, there are a couple things that distinguish it from this case. Number one, there was no argument about what the lawyer could have put on, and number two, there is a relaxed sort of rule on this. Now,
But the issue is we can't engage in meaningful appellate review. It's not as if error in a vacuum, there's strict liability in a remand. You've got to show error plus prejudice.
Right.
And absent an offer of proof, how can we possibly find prejudice, because we don't know what these witnesses would have said and it was not put on the record?
well, Your Honor, there's a pretrial statement which says what the witnesses would say.
Well, it says they will testify about business and finance. It doesn't give any specificity.
Your Honor, can I ask a question? Is that the only? There are other issues which my client couldn't have evidence on, which she didn't have a chance to put on evidence on. So I just wanted to point out that just because there's the one business issue and there's no forensic accountant, even without that issue, there was sufficient evidence in the record to show that the wife couldn't put on evidence about the distribution of assets, such as a gift of the Denali automobile, contributions to the IRA accounts.
Well, I will tell you that I do think the record has much more specificity as to those two items, including who would have testified and what they would have said. So I think you can distinguish between those. It just seemed like much of your brief was devoted to, as was the trial testimony, this kind of hodgepodge of business financial discussion.
Perhaps, Your Honor, the wife should have hired a forensic accountant, and perhaps in order to fully evaluate that issue, that would have been necessary. However, there are certain sort of preliminary or just rudimentary issues which there was the bookkeeper who had been called as a witness and didn't have a chance to testify, was outside the courtroom. at least she could have said, for instance, the husband earned this much from a transaction while they were still married. That money didn't come into the business until after the dissolution action was filed, or the benefits for purposes of child support, spousal maintenance. What sort of real benefits did the husband have from his employment with these entities? What were the tangible assets? What were the liquid assets? Those are the type of things which, even though, we didn't have a forensic accountant to say what the value was or where the money went, but still there was a prima facie amount of proof that could have been provided. But really, Your Honor, to answer your question, if you take a look at the transcript, what really happened was that when, at the end of this, when there was cross-examination going on, basically the judge just said, I've got to stop this, you can step down, and that's it. I mean, really, the attorney didn't really have a chance. Plus, it's distinguishable because this issue was brought up on a motion earlier, more than one motion earlier, up on special action. This court said, look, we can't rule on the issue of how short the trial is too short now, but it gave instruction. It said, look, you can file your list of witnesses and exhibits. I mean, your pretrial statement. If the judge determines at that time that you need more time, then you'll get more time. You have a chance to, if he doesn't give you more time, then you still have a chance to go in front of the judge and put on your evidence. And if there's not enough time, then you have the remedy, the conventional remedy of an appeal. And you got to realize, Your Honor, there were 9 witnesses sworn in this case. Maybe you never get to all the exhibits. Maybe you don't get to 257 exhibits. But even if you get to, a quarter of them, or there just wasn't enough time to explore the issues. And there were a lot of issues, Your Honor. There was still the issue of vacation parenting time. There was the issue of medical decision-making. There was spousal maintenance, child support, attorney's fees, distribution of assets and debts, including more than one piece of real property, including accounts. So there's just no way. I think, Your Honor, what this is kind of the res ipsa loquitur sort of, the thing speaks for itself kind of exemplar case, or the obscenity sort of, I'm not going to define it, but I know it when I see it. When you've got a case that you have 15 witnesses, 257 exhibits, and all these issues, and you set it for 3 hours, you see it on its face that there's been error, that there is an abuse of discretion. So that's how I would respond to that, Your Honor.
Mr. Samuels, I'm just really going to underscore what Judge Downey said. Looking at this closely, and I have read the transcript and looked at it very closely, and you raised some very good points about how this was conducted. I don't at all disagree. But as on appeal, what I'm struggling with is I cannot determine, because there wasn't an offer of proof, whether the lack of time has really caused a problem with a couple of exceptions that appear, because the record is much more complete when it comes to the IRA and the SUV. And here, once the judge issued the ruling, there could have been, for example, a post-trial motion that said, Judge, here's what happened, and it was an inadequacy in the procedure, improper procedure, and here's our offer of proof. And that would have given us the information we need to deal with this on appeal. And that didn't happen either. So I'm just really, I hear you loud and clear, but I'm struggling with the sufficiency of the record on several of the issues, at least addressed in your first main argument.
And Your Honor, this is kind of a catch-22. Because the record isn't sufficient because they didn't have enough time to go through the evidence.
But an offer of proof, your client could have made a separate offer of proof saying, okay, with not with the time, but here is what so-and-so would have testified, A, B, C, D, and E. Here's what so-and-so would have testified, 1, 2, 3, 4, 5, and that would have given us what we needed.
Your Honor, I understand what you're saying, and the only thing that I can tell you is that my review of the case law says that is somewhat of a relaxed standard, and you don't just consider whether an offer of proof was given, but you consider that, I'm not going to say the totality of the circumstances, but that's just one of the factors.
What's the best case you have then for this more relaxed standard?
I'll just, let me just get it for you, Your
And if
Honor.
you want to give it to us after on the rebuttal part of the argument, that's fine too.
Sure. But the other thing is, Your Honor, my client's case was just cut off. You have to consider the context. This judge just said, that's it, there's no more. There's just no more. And then he spent 20 pages of the transcript giving a speech. And so I don't think that we were given a real opportunity to make an offer of proof. Not only that, but there was already an instruction from the Court of Appeals on the special action which says that if you don't feel you had enough time to put something on at trial, you have the remedy of appeal. I mean, it's not like this issue was a new issue. It was brought up, these factual circumstances, these issues were brought up, and it was argued time and time again that there wasn't enough time. So I'm going to reserve the rest for your rebuttal unless you want me to answer another question right now.
No, thank you.
Thank you. Counsel, thank you.
Thank you. May it please the court. My name is Taylor Young, and I represent respondent appellee Adam Katz in this appeal. I think the court has identified the critical issue, which is always challenging for an appellee when there hasn't been an offer of proof, nor has there been very specific identification in the briefs of where prejudice can be demonstrated, and that is clearly the case here. What is suggested by Wife about a more relaxed standard on an offer of proof is a concept that I'm unfamiliar with. This court's most recent decision about time limits is the Volk case, which came out after the briefing in this case. This case is nothing like Volk. In Volk, you had a situation, as the court's well aware, where the trial court simply asked for, give me exhibits, I'm not allowing any testimony. But even there, in the Volk case, there's no relaxed standard of an offer of proof. The court identified that father's inability to testify regarding these tax returns, particularly in a modification context, was clearly prejudicial. And in that case, what had happened was that the time limits, if you could call them that, there really weren't time limits in Volk. Yeah, I think have become unreasonable. The idea of a relaxed standard also, I think, shifts the burden to appellees. It suggests that the trial court in a family law case doesn't have broad discretion to manage its calendar, and manage time limits. What the trial court has some other kind of discretion, and this court is the supervisory court that will readily second guess those decisions in absence of an offer of proof, and doing this under a relaxed standard. And I just don't think that that's appropriate, and I don't think this court should adopt any kind of relaxed standard should one exist. I did not see it in the briefing, so I really can't address the point.
Well, an offer of proof is not just for the trial court. I think an offer of proof is to permit the trial court to hear what would have been presented to decide whether maybe it's made an erroneous determination. But equally importantly, an offer of proof is to permit the appellate court to engage in meaningful appellate review. And so I'm unaware of any authority that says the Court of Appeals relaxes that standard in a family court matter or any other matter.
It seems to me that is exactly contrary to the normal standards of appellate review and
Okay, well, I
You
just
know.
threw you a softball, so let me.
Thank you. I'll
Now let me-
avoid
here it
the war
comes.
story.
Now
Here
let
we
me-
go.
Now let me zero in on what I perceive as your weak point. I do perceive a meaningful difference in the record between the business financial interests, which don't appear to be adequately disclosed pretrial or certainly through an offer of proof. But when you look at issues like the IRA and the automobile, wife's burden of proof was clear and convincing because those were assets that came in during the marriage. She estimated 10 minutes for 2 witnesses on those issues. She ran out of time, and as I read the transcript, she ran out of time in part because she spent a lot of time on business issues that she didn't have personal knowledge about, and so I think the trial court was within its discretion saying you're done with that topic. But those issues, and she had no meaningful opportunity to litigate those. Why was that proper?
Well, Your Honor, I think the question is why wasn't it an abuse of discretion, not why was it proper? Again, that shifts the burden. The question for this court is not what any one of these judges or all 3 of these judges, had you been sitting there, would have done. The question is whether
Right.
Judge
But
Norris.
As to those 2 issues, it approaches more like Volk. The business financial issues, I agree, bear no resemblance to the Volk situation, but she really didn't get to litigate those 2 issues at all.
I mean, Volk stands for makes the express point that if during the course of a hearing, it becomes apparent that the court lacks sufficient time to receive adequate testimony, then the court must allow reasonable additional time or continue the hearing to allow the to permit a performance essential tax. So here, the point, having looked at this transcript, it seemed to me that it became apparent on those 2 issues that Ms. Cretson needed additional time.
Well, Your Honor, I guess the question I have is, I'd like to point the court to the transcript on page 105. It's a specific comment, one of many that Judge Norris made about hiring a forensic accountant. If the court's reviewed the transcript, the court's seen numerous references. They were also in the transcript of the hearing regarding the continuance, and they're in the decree. So we know that Judge Norris thought a forensic accountant would have been a good idea here. But what Judge Norris said also at page 105 is specifically talking about this. He says, after talking about a forensic accountant, he says we could have done it in, half an hour, 45 minutes, all the business stuff. So when the court sets a 3-hour trial with an hour and a half for one party to present a presumptive hour and a half, and that party goes through their own choices, for their own choice not to hire a forensic accountant and not to use their time wisely on the stand, when that party takes vastly more additional time offering what I think the court recognizes as pretty speculative testimony regarding these accounts, that essentially puts the party in the driver's seat of whether or not time limits have become unreasonable. And what I would say here is that the time limits didn't become unreasonable because of the action of a third party, because the issues became more complex through some non-fault. The trial time became compressed for this litigant because this litigant chose not to get a forensic accountant and chose to spend her time on that issue. So I think that distinguishes Volk.
I'm not sure. I know you're the master of the record, and I'm kind of just an interloper here, and you lived it, and I've just kind of observed it. But in looking at it, it was my understanding that it was Ms. Credson's parents who, she alleged, gave her the funds or the money to pay off the debt on the SUV. Therefore, whether a forensic accountant would be relevant, wouldn't have thought so. The testimony needs to come from the parents.
Correct, Your Honor, but if she spends most of her trial time talking about something else and there are 5 or 6 other issues and she chooses not to get to those issues, that's a choice about how she litigated the case. It's not a situation in Volk where we have, Volk is really distinguishable. I know I know the court has actually reviewed the video on Volk, so it's very distinguishable from this situation. In this situation, what we have is a litigant's choice.
Let me interrupt you, just because I get that it's abuse of discretion, and I'll just say, point blank, I would not have made the same decision as the trial judge on the time allocation, but that's not the standard of review. So I'm
Correct.
going to give him deference as to the issues that were actually litigated, and sometimes litigated not in a way that was conducive to easy, quick resolution. But I do think that when there is a statement that it will require 20 minutes to resolve property issues that the court's heard nothing about, at some point it becomes unreasonable not to consider those, especially when the court itself consumes so much time with its own comments. I mean, really, if you look at how much time each party had in this case, even though I know that the wife got more than the husband ultimately because the court gave her an additional 10 minutes for cross-examination, there wasn't much time to talk about medical decision-making for the child, vacation time, business finances, IRA, buying a home, the vehicle. And so at some point, I just think you can't resort to the mantra of, well, abuse of discretion and she spent too much time on businesses. I mean,
Well, Your Honor, I guess one of the things that I would respond is up on appeal, and again, I have to look at what issues have actually been raised. Medical decision-making is not an issue that's up on appeal. It was an issue.
no, but
in
it
the-
was reasonable for her to spend time at the trial on that issue because it was disputed still.
That's right. I'm responding to your observation that there wasn't very much time spent on that issue, but that issue isn't up on appeal. Trying to determine what is up on appeal based on the briefing, there's sort of this plethora of running downhill at the end of and everything else, and that becomes a little bit difficult. There's no specific references in the record for it, so it's a little difficult to understand what issues were going to be litigated that weren't under based on the briefing itself. So that's this court's job, I think, is to also hew to the appellate review standard, of course, and not substitute its judgment for that of the trial court, and particularly not to do it when the briefing doesn't raise the issue.
So the argument is not that there wasn't enough time to address the issues regarding the SUV and the IRA, but that within the allotted time she misallocated her time, so that's her fault and not the trial court.
Right, and certainly not Mr. Katz's fault or his counsel. And Judge Norris, I didn't live this. I've lived it in the record.
Oh, okay.
I didn't live at a trial, and neither did Mr. Samuels, I believe. So we're here on the cold record just like the court is. Well, unless the court has any further questions, I just simply ask the judgment and decree be affirmed.
Thank you.
Oh, Your Honor, can I take that back? I have 1 minute and 20 seconds.
Actually, you have more, but we're not going to
Oh,
tell you.
that's correct. Well, I'll try not to take much time. The court will see that both sides have asked for their attorney's fees on appeal. One of the issues about financial disparity, which is something that the court must consider statutorily in determining an award of attorney's fees, is the financial positions of the parties changes over the course of the appeal. We filed an updated AFI yesterday because the case will be submitted today. But we would ask the court, when it gets to determining attorney's fees, if it so chooses, we would certainly welcome the opportunity to provide further updated financial information if we can.
Thank you.
Thank you.
Rebuttal, Mr. Samuels.
Thank you, I'm back. Okay. The relaxed standard that I was talking about is actually quoted in the Gamboa case. Okay, the very last page, it's the personal injury case. It says, plaintiff was required to but did not make an offer of proof. It involves a hostile witness, and the quote says, given that counsel normally does not know in advance what a hostile witness will say on cross-examination, the offer of proof requirement concerning a claim on appeal is relaxed. Well,
That didn't really help.
it doesn't really help. However, that's where I got this. That's where I got that. The real issue, though, is this is a new case. This is a case where these folks was thrown in on a 3-hour trial, and my clients and her attorney have to do triage, and my client gets cut off in the middle of cross-examination, and I don't believe that the attorney would have thought that she even had an opportunity to make an offer of proof, because the judge said, get everybody in here, that's it, no more, get everybody in here, and then the judge went into a 20-page speech.
Counsel, was there any attempt to make an offer of proof?
You know, it might be something for the video, but I don't believe that, based on my review of the transcript, that there was I believe it's reasonable to believe that counsel did not believe that she had an opportunity to make an offer of proof, or to even refer to any additional evidence that she would put on at all.
Well, I don't think that's accurate, because at one point, wife's counsel specifically told the court, I've run out of time, I don't even have time to put on any evidence about the IRA, and she again re-urged her request for more time. So I'm not sure what you just said.
Speaking about the very end of the trial, Your Honor.
Right.
The very end of the trial, when the attorney is cross-examining Mr. Katz, and the judge says, that's it, I don't want any more of this. I can actually give you the quote.
I think it's, from my recollection, I think you make a good point that the parties or their attorney, Ms. Katz's attorney, did not have time, given the circumstances, to make an offer of proof during the hearing. Where I am concerned, though, there was opportunity afterwards through post-trial motions. If that had happened, then we would have, for appellate review, this point Judge Downey made a little while ago, we would have a record so we could really examine how the evidence that you would have liked to have put on versus what happened at the hearing, and that's where we are struggling.
And Your Honor, that's a good point. The only thing that I would say is, I don't know how that jives with the fact that you don't have to make a motion for new trial or other post-trial motions in order to file a notice of appeal and assert issues on appeal.
But you still need to give us a record. We have to have information and facts to decide a case.
I believe that there was enough on the record to at least determine that there may have been assets in the business, that the husband may have earned income during the marriage, which he took after the filing, and there may have been other monies which the wife was entitled to. In addition, Your Honor, there was also a $65,000 down payment on the 82nd Street property, which was there was no opportunity for the wife to put on that evidence either. So, I think if we take a look at this in the totality, we're looking at somebody with the impending job of having to put on all this evidence in a 3-hour time frame, and they motioned and filed and special action and did everything they could because they knew that it was going to take more than 3 hours, and they certainly didn't get on even a fraction of the evidence that they wanted.
Let me ask you about a point Mr. Young made. You've identified in your opening brief at least four witnesses who you say would have been called to testify about business and finances: Chernikoff, Radevsky, Wallen, and Jayberg. None of those witnesses were present at trial according to the minute entry.
Well, Your Honor, let me just refer to the ones who were present then.
Well, I know who were present because they were identified in the minute entry, but those are the ones you say in your opening brief you intended to call, but they weren't present. So how could they have testified that day?
Your Honor, I don't know. Maybe that's that may be my mistake, but I can tell you that there were 9 witnesses who were sworn in.
I know that from the minute entry, right? But they were
so
none of these people.
There was the main one that we talked about who was outside was Judy Corrigan, the bookkeeper, who would have been the person who had inside knowledge as to the business and the assets of the business. There were other, Keith Swart, who was also knew about business dealings. There was an appraiser. There was the father, the mother, those folks too. So, yes, you're right, Your Honor. You're absolutely right. They weren't there. But frankly, because of the fact that there were only 3 hours, they had to do some triage, as I said. They had to figure out, well, who are the most important witnesses that we have? Given the fact that we don't have a forensic accountant, we'll take the bookkeeper, but that's it. That's all we have a shot at. Any other questions?
No, thank you.
Thank you.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court will stand in recess pending our next argument. Thank you.